Good afternoon and welcome to the final webinar in our series on rural litigation. My name is Stephanie Hepburn. I'm a solicitor in our Dispute Resolution Department specialising in property litigation. As well as commercial litigation, I have a focus on rural litigation and work with a wider rural property business team to help our clients avoid disputes and resolve disputes. Our aim is always to resolve disputes without involving the court, but where it is litigation necessary, I have experience in the Court of Session, Sheriff Court, Land Tribunal and Land Court.
And I'm Julia Kidd, an associate in our rural property team. Our team deals with buying, selling, leasing all types of property, as well as providing advice on land and estate management, services, access and title conditions. As you may know, we've produced 2 previous webinars in this current series and hope to roll out more in the future. Our first webinar on way leaves was published on 20th of April, and the second webinar in May covered criminal liability in the countryside. Recordings for both of the 2 previous webinars in the series are available on Vimeo, and there's a link on the screen just now. Today's webinar will focus on private residential tenancies, current reform and the impact on rural rented properties. If you have any questions as we go along, please type them into the box on your screen and we'll try to get as many as we can at the end. Julia is going to start by giving a summary of the current position for residential tenancies before we look at some of the changes that are coming in. We'll then try and illustrate how the changes will affect you in practice, so once again using our fictional farmer Archie Pickle. Finally, we'll briefly cover a couple of other points that might be of interest. Over to Julia. So under the current legislation, residential landlords and tenants can enter into either short assured tenancies or assured tenancies. These are often referred to as SATs and ATs respectively. Both of these types of residential tenancies have been in operation since the late 1980s. The defining difference between an SAT and an AT is that a tenant under an AT has security of tenure even after the contractual end of their tenancy agreement. In short, this means that the tenant has special protection from eviction, whereby the landlord cannot remove the tenant from the property before carrying out certain proper legal steps. So Steph, what does a landlord currently have to do in order to remove a secure tenant under an AT?
Well, firstly, the landlord must serve a notice to quit an AT6 form specifying the grounds for eviction. There are 17 grounds for eviction under the current legislation, which are listed on the slide. As you see from the current slide, some grounds are mandatory and require the courts to grant an eviction order, and some are discretionary, and the courts must choose as to whether eviction is appropriate in a particular case. The notice must also be served on the relevant local authority under the Homelessness Scotland Act 2003. The landlord must then raise a court action and satisfy the court that the ground referred to in the AT6 does actually exist in practice.
And how does this differ in comparison with a short assured tenancy where the tenant does not have security of tenure?
Well, in order to create an SAT and prevent the lease from becoming an AT, the landlord must serve an AT5 notice at the outset of the tenancy. This then gives the landlord the ability to end the tenancy at the end of the lease, provided the landlord has served notice to quit and a Section 33 notice, which is a notice of the landlord's intention to raise proceedings in the court for recovery of possession. As there is no requirement to satisfy any particular ground for eviction here, this gives the landlord much more flexibility in relation to removing a tenant at the end of the lease, making SATs the most common type of tenancy in Scotland. However, both SATs and ATs will soon be replaced with a new type of tenancy under the new Private Housing Tenancies Scotland Act 2016, which we'll refer to as the 2016 Act. And Julia is now going to give a summary of this new legislation.
Thanks, Steph. The 2016 Act replaces SATs and ATs with a single form of tenancy, the Private Residential Tenancy, or PRT, and will likely come fully into force in late 2017 or early 2018. This new type of tenancy will give security of tenure to all PRT tenants. The 2016 Act represents one of the most significant developments in the private residential sector in recent years and makes wholesale changes to private tenancies. In summary, the Act makes provision for how PRTs are created, what kinds of tenancies can be PRTs and which ones can't, the information which the landlord must give to the tenant, statutory terms that will be common to all PRTs unless otherwise stated in any regulations, how the rent payable by the tenant can be changed and how rent increases can be capped, how PRTs can be ended and the tenant removed, and what happens to the tenancy if the tenant dies.
Thanks, Julia. In our previous webinars, some of you may recall we used the example of a fictional farmer, Archie Pickle, who lives on Pickle Farm, to illustrate how the law would operate in practice. And we're going to continue with Archie Pickle's story in today's webinar. When we left him in previous webinars, Archie had resolved his disputes with the various utility suppliers in webinar 1 and was happy running his farm and estate, which he inherited in webinar 2. Let's go back to Pickle Farm and find out what's been happening since we've been away.
Well, Archie, not content with only running the farm, holiday let business and shooting estate, has decided to scratch his entrepreneurial itch and branch out into a new area. He's built a number of small cottages which he intends to let out as private residences. They'll look in particular at Apple Cottage, Pear Cottage, Banana Cottage and Strawberry Cottage. Firstly, being new builds, Archie's confident that the cottages all comply with the repairing standard, that the cottages are all wind and watertight and appropriate for letting and comply with current legislation, including standards for smoke alarms, carbon monoxide detectors, gas and electricity, and have energy performance certificates. If the cottages were converted or renovated estate cottages, Archie would have needed to carefully check that the cottages were all up to scratch, compliant with legislation and suitable for letting. Next, Archie will have to register as a landlord. This is because since the 30th of April 2006, landlords renting a residential property in Scotland have been required to be registered with the local authority where the property is located. In order to be registered, the landlord has to be a fit and proper person. So what factors will the local authority take into account in dealing with applications for registration?
In looking whether to register a particular landlord, the local authority must take into account any offences committed by a potential landlord, including those involving fraud, dishonesty, violence and discrimination. In addition, the local authority will also look into whether the potential landlord has ever contravened the housing law, landlord and tenant law or antisocial behaviour laws affecting a house they let or manage. It's now an offence if a person owns residential property in Scotland that is let and is not registered as a landlord unless they are covered under the exemptions under Part 8 of the Antisocial Behaviour etc. Scotland Act 2004. And the exceptions to registration includes where the property is the main residence of the landlord and there are not more than 2 lodgers renting from the landlord, if the property is let under agricultural tenancy and occupied by the agricultural tenant, and I should emphasise here that what Archie is doing is letting cottages as private residences as opposed to letting property on an agricultural basis. Other exception is if the property is let under a crofting tenancy or occupied under a life rent, or if the property is used for holiday lets only or is let to members of the landlord's family only. As Archie has previously only had holiday lets on Pickle Farm, he was previously exempt from registration. However, because he now wants to let private residences, if he was not to register himself as a landlord for new cottages, he could face a maximum fine of £5,000 and the local authority could also have notice on him, meaning no rent would be payable. The process for registration is simple and can be completed online. It lasts for 3 years and costs £55 for each local authority the landlord is applying to and a further £11 per property registered.
Following registration, Archie had a happy first foray into the rental market, finding enough prospective private tenants to rent out most of the new cottages. As the 2016 Act is not yet in force, these tenancies are all either SATs or ATs, and Archie complies with all of the rules prescribed by the relevant legislation in relation to these tenancies.
One thing in particular Archie has to be careful to comply with is the Tenancy Deposit Scheme. Under the Tenancy Deposit Scheme in Scotland Regulations 2011, Archie is required to pay any deposit to the scheme administrator of an approved tenancy deposit scheme. There are then certain procedures he wants to follow if he wishes to retain all or part of the deposit at the end of the tenancy. If these are not followed, the regulations allow penalties of up to 3 times the amount of the deposit. There have been a couple of cases in the Sheriff Courts on this point, and in the case of Fraser against Meehan, the full 3 times deposit penalty was applied by Edinburgh Sheriff Court. In another recent case, Cooper against Marriott, Sheriff Sheehan at Edinburgh Sheriff Court emphasised that the status of an amateur landlord is not recognised. If you rent to the public on whatever scale, you're covered by the regulations.
A few of the cottages remain unoccupied, and Archie, ever the businessman, is looking to market these remaining cottages and find tenants for them.
He's heard the law on residential tenancies is due to change. While the new Act is not yet in force, it is likely to come to force in 2017 or 2018, and Archie wants to be prepared and know about the changes that are proposed and how these will affect any new tenancies he agrees for cottages once the Act is coming into force, and indeed how the changes might affect his current tenancies. Julia, what new changes by the new Act should Archie know about?
Well, Steph, the first thing to be aware of is that there's no automatic conversion of existing SATs and ATs when the 2016 Act comes into force. So for the SATs and ATs which Archie already has entered into, those will, subject to a point on succession, which we'll talk about later, continue to remain in force and be governed by the existing legislation. Once the 2016 Act is in force, however, Archie can't enter into any new SATs or ATs and will have to enter into the new style of tenancy. The most significant changes to the law made by the 2016 Act relate to how Archie could bring a tenancy to an end and get rid of any of his current tenants for whatever reason. Another very important change for Archie to be aware of is that there are certain restrictions on his ability to review the rent which his tenants pay to him. We'll look at those changes in more detail later, as we find out that Archie has a few concerns about how his ability to change rent levels and evict tenants could be affected. It's worth highlighting at this stage that Archie's holiday let business will not be affected by the 2016 Act, as Schedule 1 expressly states that holiday lets can't be classed as private residential tenancies. The same applies to any agricultural tenancies or rent-free licences to occupy, for example, that might have been granted to employees in order to allow them to live in cottages for the better performance of their duties.
Thanks, Julia. As we've mentioned already, the new tenancy replacing SATs and ATs is called the Scottish Private Residential Tenancy, or PRT. The 2016 Act states that Scottish ministers may prescribe certain statutory terms that will apply to every PRT. The government also plans to publish a model tenancy agreement, which will give us a template for PRT leases, setting out mandatory terms as well as model clauses that parties can use, and giving tenant information that's currently contained in a tenant information pack. Unlike with SATs and ATs, therefore, there will be a template for Archie and his tenants to use as a starting point for the tenancy agreements. Archie should have to include these new mandatory terms in any new PRT arrangement he enters into, which may result in these new tenancies being different from the current SAT and AT leases. For example, if a tenant pays Archie in cash under the new legislation, Archie is required to provide them with a receipt showing the amount paid and whether there are any outstanding arrears. Many of the new provisions are aimed at protecting tenants, but Julia is going to quickly discuss if this is the case with all of the new provisions in the new Act.
As well as protecting tenants, the 2016 Act also places requirements on tenants. Let's look first at Apple Cottage. Apple Cottage is currently empty, but one of Archie's friends, Brona, has indicated she would like to rent Apple Cottage from Archie in the future once the Act is in force, and she'll be looking to take on a new PRT in her name only. She also has a 17-year-old son and a 14-year-old daughter who will be living with her, although they won't be joint tenants. As her son is over the age of 16, Brona will be required to notify Archie of the fact that her son will be living with her. Archie must be notified of her son's name and his relationship to her. Brona also has a friend who may stay in the cottage for short periods from time to time. Brona would also be required under the 2016 Act to notify Archie if her friend will be staying in the cottage as a lodger and must obtain Archie's written consent for this. The same would apply if Brona was looking to sublet or assign her tenancy.
To show how rent reviews work under the current system, we'll look at David, who lives in Pear Cottage. David rents Pear Cottage from Archie under an assured tenancy. When the tenancy was agreed to, the rent was set at £350 per month. 6 months pass and the private rental market shifts, meaning the amount of rent payable by David no longer represents the value of the tenancy. Archie sends a notice to David proposing a 10% increase in rent, which David is not too happy about. Under the current legislation, David can refer this proposed increase to a private rented housing committee, which is then required to consider what rent would be reasonably to be expected if the cottage has been let on the open market under an assured tenancy, on the same terms and beginning on the same date from which the proposed rent will be payable.
So how will this process change once the new Act is enforced for Archie's tenants that have new PRTs?
Well, the first major change which Archie wants to take note of is the rent payable under a PRT will not be able to be changed more than once every 12 months. This would mean, for example, that if the market moved considerably and Archie proposed a rent increase in September 2018, for example, which was ultimately accepted, Archie could not then propose a further increase in December 2018 if the market changed again. So let's go back to Brona at Apple Cottage in the future, and assume we're now in the future and Brona has rented Apple Cottage on a PRT. Looking at Brona's position under a PRT, let's look at more certainty about how much rent she will be required to pay for Apple Cottage. For Archie, it will mean it will be even more important to get the rent review right first time. Under the new Act, Julia, how would Archie go about proposing a rent increase?
Well, as before, Archie will be required to send a notice, this time called a rent increase notice, to Brona. This will have to be sent 12 weeks before the proposed increase date, which must be stated in the notice, along with the proposed increased amount. For instance, if Archie proposed an increase of 10%, but Brona believed this was too steep, she could challenge this proposal. Rather than referring the proposed increase to a private rented housing committee, Brona will be able to refer the matter to the rent officer for that particular area under the 2016 Act. The rent officer will then be required to consider matters similar to those that the committee currently take into account. The new rent will be determined in accordance with the rent that would be payable if the cottage were to be let under a new PRT on the same terms and starting from the date on which the proposed rent will take effect. The rent officer would have to disregard any positive effect on rental value attributable to any work paid for or carried out by Brona on Apple Cottage, unless she had been required to pay for or do such work under the tenancy agreement itself. Conversely, any negative effects on value attributable to Brona's failure to comply with the terms of the tenancy will be disregarded. So what would the position be if any improvements not required by the tenancy agreement had been made to Apple Cottage since the tenancy began?
Well, the landlord, or Archie in this case, could apply to the rent officer to determine the amount by which the rent could be increased due to any improvements carried out by Archie since either the start of the tenancy or since the last time the rent was reviewed. The government does plan to release guidance on what constitutes an improvement for these purposes and how much the rent will increase on the basis of any particular improvement, and the rent officer will have regard to this guidance once it has been published. However, if Brona pays for the improvements herself, or the improvements are for decoration, for example, if she adds new window frames that are more aesthetically pleasing than the old ones, these will not be taken into account by the rent officer. If the rent officer makes an order and Archie is unhappy about the increase proposed, Archie will be able to challenge the decision. In fact, before the final order is made, Archie will have had an opportunity to voice dissatisfaction about the proposed rent. The rent officer must issue a provisional order which sets out the rent they intend to propose in their final order, and either Archie or Brona will be able to ask the rent officer to reconsider this amount. If for whatever reason the amount in the provisional order is not changed, there is a further avenue open to landlord and tenants. Archie, and indeed Brona, would be able to appeal the order to the first-tier tribunal within 14 days of the order being made. The first-tier tribunal would then have the power to set the rent, taking into account the same factors which the rent officer took into account during their deliberations.
Another of Archie's current tenants, Emma, has just moved into Banana Cottage under an SAT. The tenancy is due to last for 1 year, at the end of which Emma is due to move out. Archie's already lined up a new tenant in anticipation. When the time comes for Emma to move out of Banana Cottage, all Archie has to do to remove Emma under the current rules for short assured tenancies is to serve a notice to quit on Section 33 notice, as we mentioned before, in advance of the end of the tenancy and in accordance with the notice provisions specified in the legislation and in Emma's lease. Provided that the notices have been served correctly and timelessly, Emma is then required to leave Banana Cottage at the end of the term of her tenancy. She does not have to have done anything in particular to justify the termination of a tenancy, commonly referred to as the no-fault ground for termination. Her tenancy is simply at an end. However, Archie is aware that the process for terminating the tenancy will change for PRTs as a result of the new legislation.
How will Archie remove Brona from Apple Cottage at the end of her tenancy, assuming it is a PRT?
Well, the first thing to note is that PRTs may not have any set duration. The parties are not required to state an end date in the tenancy agreement, and even if an end date is stated, this does not mean that the tenancy will automatically terminate on this date. Archie will only be able to gain vacant possession to Apple Cottage on certain grounds. As we mentioned before, all PRT tenants will have security of tenure. The so-called no-fault ground will no longer be available to landlords, and instead, landlords will have to serve a notice to leave, citing one of the grounds for eviction specified in the 2016 Act. It's also important for Archie to note that the tenancy will not terminate solely because Brona leaves and no longer occupies Apple Cottage as her principal home. The formal notice to leave procedure set out in the 2016 Act should technically be followed in each case. If Archie sends a notice to leave to Brona specifying a ground for eviction per the 2016 Act, and she does in fact voluntarily and happily leave, this will be sufficient to bring the tenancy to an end. However, if Archie serves a notice to leave on Brona and she refuses to leave, her tenancy will continue until Archie can prove one of the grounds for eviction given in the 2016 Act and obtain an order for eviction from the tribunal. So how does Archie remove Brona and end the tenancy if she's refusing to leave?
Well, we know that Archie has served his notice to quit on Brona. If Brona had been occupying Apple Cottage for 6 months or less, then Archie would have to have given Brona a 4 weeks notice, and if Brona had been occupying the cottage for more than 6 months, he would have to have given her 12 weeks notice. It's only upon expiry of the notice period that Archie will be able to take the next step in the process. The next step is for Archie to apply to the First Tier Tribunal for an eviction order, which will be granted by the Tribunal if one of the eviction grounds in the Act applies. Archie must send a copy of notice to quit he sent to Brona to the Tribunal along with the application, and must also notify the local authority of his intention to apply for the eviction order. The Tribunal will only grant an eviction order if one of the grounds for eviction in the Act applies. There are 18 grounds for eviction in total, and the mandatory grounds are as follows. A. Archie intends to sell the cottage. B. Archie's bank intends to sell the cottage as Archie is in default on his mortgage. C. Archie intends to carry out reconstruction work on the cottage, and it would be impractical for Brona to live in the cottage while this is being done. D. Archie intends to move into the cottage and live there as his principal home for at least 3 months. E. Archie intends to change the use of the cottage, for example, use it to store his farming equipment as opposed to for residential purposes. F. Brona has abandoned the property. G. If the tenancy was given to Brona on the basis she was an employee of Archie, for example, if Brona was managing Archie's holiday let business, then Brona ceases to become an employee. H. If the cottage is to be used for a religious purpose. Or finally, I, if Brona has been convicted of an offence or engaged in criminal behaviour. This ground will be mandatory if Brona committed the offence by using Apple Cottage, or allowing it to be used for illegal or immoral purposes, or if she committed the offence within or near to Apple Cottage, and the offence is punishable by imprisonment.
There are also various discretionary grounds for eviction, namely, A. A member of Archie's family intends to move into the cottage and use it as their principal home for at least 3 months, and the tribunal satisfied it's reasonable to grant an eviction order on that basis. B. Brona was only given the cottage because it was assessed that she needed community care under social work legislation, and she's now been assessed as no longer having that need. C. Brona has failed to pay her full rent over 3 consecutive months. Now, this is actually a mandatory ground for eviction when the amount due equates to more than 1 month's full rent, as long as Brona's inability to keep up with the rent payments is not due to delay in payment of her housing benefits. Otherwise, that's a discretionary ground. D. Brona's been engaged in relevant antisocial behaviour. E. Brona associates in the let property with someone who has a relevant conviction or has been engaged in relevant antisocial behaviour. F. Brona has broken any other term of the tenancy agreement other than paying the rental payment. G. Archie has ceased to be registered with the local authority as a private landlord. H. Apple Cottage was actually a multiple occupation property. It needed an HMO licence or a house with a multiple occupancy licence, and Archie's HMO licence has been revoked. And I. An overcrowding statutory notice has been served on Archie. Now, many of these grounds are similar to the existing legislation, but the 2016 Act does introduce new grounds on which Archie could potentially have Brona evicted, such as his intention to sell the cottage or to change its use. However, by and large, the 2016 Act does mean that Brona will have increased security of tenure, primarily by the removal of the no-fault ground. Is there anything else that Archie would have to be aware of, Steph?
You should know there is no general catch-all ground for eviction which would allow the Tribunal to order eviction in any other reasonable circumstances. Archie will therefore have to prove that one of the eviction grounds applies, and if he cannot, then he will not be able to remove Brona. In terms of the legislation, Archie and Brona cannot, strictly speaking, simply agree between themselves that tenancy should be over and end tenancy that way. They are obliged to follow the procedure set out in the Act, which includes complying with the relevant notice periods. While Archie will not be able to end the tenancy by simply sending a notice to quit to Brona, Brona will be able to end the PRT by sending a written notice to Archie, which specifies the date on which tenancy is to end, as long as it's given freely and without coercion of any kind. I think it will be interesting to see how this develops in practice, and from the landlord's perspective, there's a definite advantage keeping tenants in under SATs if at all possible.
Suppose, looking to the future, that Archie applied for an eviction order and the Tribunal has refused to grant one. This is on the basis that Brona is a perfectly good tenant with no rent arrears, no convictions and no breaches of the tenancy agreement, and that Archie does not intend to move out of his large residence on Pickle Estate and move into one of the much smaller cottages. Nevertheless, Archie's managed to get Brona to leave Apple Cottage, but unfortunately for Archie, he's done so through trickery and deceit. What happens then?
Well, fortunately for Brona, she'd be able to apply to the Tribunal for a wrongful termination order. The Tribunal would make an order if it found Brona had been misled in ceasing to occupy Apple Cottage by Archie. This order could require Archie to pay Brona compensation up to a maximum of 6 months' rent. A copy of the order would also be sent to the local authority with which Archie is registered as a landlord.
And what if the eviction order was granted, but only because Archie told the Tribunal that he did intend to move his farming equipment into Apple Cottage and stop using it for residential purposes, but in fact he had no such intention?
Well, in that case, Brona could still again apply for a wrongful termination order, which the Tribunal would grant if it found the Tribunal had been misled by Archie into granting the eviction order in the first place. So whether there's been an eviction order or not, Brona would have a means of redress if Archie has wrongfully removed her from the cottage.
In the final cottage which Archie has currently let out, Strawberry Cottage, there's an elderly tenant, Georgia. Sadly, Georgia's just been diagnosed with a serious illness, and Archie's therefore being forced to consider what will happen to the tenancy should the worst happen to his tenant. Currently, the tenancy is a short assured tenancy, and this will not automatically change on the date the new Act comes into force. However, the death of the tenant is a trigger point. So if Georgia should pass on after the 2016 Act has come into force and Georgia's spouse or civil partner succeed to her tenancy, then Georgia's SAT would become a PRT in her surviving spouse or civil partner's name. This means that as more and more SATs and ATs are inherited and convert to PRTs, landlords such as Archie are going to need to be aware of the different requirements and processes that apply to these tenancies. It's also important for landlords to be aware that upon succession of an SAT, where the deceased tenant did not have any security of tenure, the new tenants will actually be in a far stronger position than the previous ones with regards to rent increases and termination of the tenancy. Effectively, the person inheriting from an SAT tenant will receive a better right than the deceased tenant had, as the beneficiary becomes a PRT tenant.
So, moving on a couple of years down the line, in 2018, once PRTs are fully in force, David moves out of Pear Cottage. Because Archie's cottage is so keenly sought after in the area, Archie has soon an expression of interest from a retired army veteran called Harold. Harold also appears to be fairly elderly and will be taking on a tenancy in his sole name. Once again, Archie is unfortunately required to consider what consequences Harold's death would have on a tenancy status, which would be a PRT in our example here. Julia, who would it say to a PRT tenancy?
Well, the first person who could potentially inherit a PRT under the 2016 Act is Harold's wife. In order for her to inherit, Harold could not have inherited the tenancy from someone else. He would have had to have told Archie that his wife was living in Pear Cottage as her principal home, and she would have had to have actually been occupying Pear Cottage as her principal home at the time of Harold's death. However, if for some reason Harold's wife could not inherit, there's a secondary group of people who could be entitled to inherit a PRT. This group could include the tenant's parents or grandparents, children, stepchildren or siblings. So for example, one of Harold's grandchildren might be able to inherit on Harold's death, but again, as long as they were over 16 years of age at the time of Harold's death, as long as they were occupying Pear Cottage as their principal home at that time and had been doing so for at least 12 months prior to his death. Importantly, if there's multiple family members in this secondary group who could inherit, they would become joint tenants upon inheriting the PRT.
As Harold is an elderly gentleman with some aches and pains from his army days, which means he has to use a wheelchair, he has a personal carer who permanently resides in Pear Cottage with him. Would his carer have any right to inherit?
Well, yes. If a spouse, civil partner, cohabitant or other family member couldn't inherit the tenancy, then Harold's carer might be able to inherit. Again, they would have to have been occupying Pear Cottage as their principal home at the time of Harold's death, and have been doing so for 12 months prior, having given up their previous lonely or main home.
Moving away quickly from Pickle Farm and Archie's business, Archie's daughter is about to go to university in Edinburgh, so he's thinking about buying a flat for her to live in. One matter for Archie to be aware of before purchasing the flat is the recent change to the tax paid in Scotland when buying property known as Land and Buildings Transaction Tax, or LBTT for short. LBTT has different rates and bands of tax to the equivalent tax that applies in England and Wales. However, Archie has also heard that buy-to-let purchases are also subject to LBTT. As Archie is not going to be charging his daughter to rent to live in the property while she's at university, he is a bit confused about whether this would apply to him. Julia, can you shed any light on this?
Well, I can understand where the confusions come from. In the press, this additional LBTT charge is often referred to as a tax on buy-to-let properties. The official name for this tax is the Additional Dwelling Supplement, which hints that it applies to purchases of additional properties and not just buy-to-let properties. The charge will be payable in addition to LBTT at a rate of 3% on the entire value of the property. A more comprehensive look at the Additional Dwelling Supplement can be found on our website, and we've included a link on the screen. Looking into the future, to a time when the 2016 Act is fully in force and Archie's daughter's finished university, Archie begins renting out the flat in the centre of Edinburgh. By this time, rent in this part of Edinburgh has been rising and rising for a number of years, and tenants in this area are becoming concerned that there may be no end in sight to the increases. Thus, is there anything that the tenants will be able to do under the 2016 Act in order to prevent continuously increasing prices?
The tenants themselves will still be unable to prevent these increases other than by referring their individual case to a rent officer as previously discussed. However, the local authority can send a request to the Scottish ministers that the area is designated as a rent pressure zone, or RPZ. If the ministers declare the area of Edinburgh as an RPZ, the rent in that area will not be able to be increased by more than a certain percentage, and that percentage will depend on regulations made by the Scottish ministers in the future.
So will tenants and landlords be able to put their case forward at all?
Yes, the ministers will have to consult both people representing tenants' interest in the areas proposed as an RPZ and those who represent interests of those who offer property for let in the area, like Archie. This should allow for both tenants and landlords to be represented in the process of choosing whether to designate an area as an RPZ. It's a bit uncertain at this point in time, unfortunately, whether any RPZs will be created in the future.
I hope that this has been a helpful look at the law relating to private tenancies and upcoming changes. We are aware that it can be seen as a daunting area of law, so we're always available to answer any questions you might have. Before we leave you though, here's a few key tips if you or your clients are seeking to let out properties for residential use. Before you enter into any tenancy agreement, make sure you understand your obligations, both under the agreement itself and under statute as a landlord. We spoke about landlord registration, but there are also a number of practical points which we mentioned to do with the standard of repair of the properties to be let. Things like smoke alarms, carbon monoxide detectors, gas, electricity testing, etc. all need to be dealt with. The reforms are due to come fully into force in late 2017, early 2018, but SATs and ATs in place at that date will not automatically transfer over to become PRTs unless they're inherited. From a landlord's perspective, it would be worth avoiding terminating existing SATs in place if possible, even once the reforms have come into force if you can, as there's a definite advantage to you in having tenants on SATs if problems arise in the future, not least because of the loss of the no-fault ground for removal, or if you're seeking to review the rent.
We do have one question on the screen, and that is, can you serve a notice on a PRT tenant for the cottage to be used by an agricultural or estate employee? I think Julia's going to pick up on that.
Yeah, that was certainly something that was lobbied for at the time of the consultation, but unfortunately it's something that didn't come in, so it's not a possibility to serve a notice on a tenant for that reason.
That's all we have time for at the moment. If anyone has any questions, please feel free to get in touch with myself or Julia. We're happy to answer any questions offline. This has been the final webinar in the series on rural litigation. If you have any particular topics you think it would be helpful to cover in future series, please let us know. We're happy to take your suggestions. Thank you for listening.